This is Jennifer Wilson and Kelly Holliday. We'll be presenting Jess Beard versus the Board of Professional Responsibility, which relates to the rule as it relates to the rules we studied in week 3. This case is cited at 288 Southwest 3rd at 838. The Supreme Court of Tennessee at Knoxville. The style of the case is Jess Beard versus Board of Professional Responsibility. We're looking at Rule 1.2, specifically Section A, or Paragraph A. The rule addresses the scope of representation and allocation of authority between clients and lawyers. And in our case, our lawyer is in trouble relating to the matter highlighted here. A lawyer may take such action on behalf of a client as impliedly authorized to carry out the representation. What we're going to find out in our case is our attorney did not take action on behalf of the client as the client should have expected him to do. Our story begins with Mr. Jess Beard, who is an attorney in Chattanooga, Tennessee. He'd been practicing since 2008, since 1990. And in September of 2003, Mr. Beard was hired by Mr. Clayton Murray Jr. For a child support dispute with Mr. Murray's ex-wife. There was a hearing on September the 8th, 2003, and the trial court did not issue its order that day. It took the case under advisement. But what we find in reading the case is that Mr. Beard told his client that he really expected him to have to pay between $10,000 and $15,000 in back child support. His suggestion was that he try to settle the case quickly. They made an offer of right at about $6,000. Obviously, the other party wasn't having any part of that. On October the 13th, the trial court rendered its written opinion. On the 14th, Mr. Beard received a copy of the opinion. He called Mr. Murray and he said it looked like he was going to have to pay his ex-wife child support or back child support of $15,000, but he had not yet read the opinion, so he would do that and he would call him back. On October the 15th, still not having read the court's opinion, Mr. Beard called his client and told him that his ex-wife had made a counter offer of $10,000. And he advised him to accept the $10,000 offer and to hurry up, get a check, and get it over to the ex-wife's attorney before they had a chance to look at the court's ruling. So, Mr. Murray took the $10,000 over to his ex-wife's attorney, and they signed an agreed order on October the 15th, settling their child support dispute for $10,000. 5 hours after the party signed the agreed order, Mr. Beard finally read the trial court's order. The judge, or the trial court, found that Mr. Murray did in fact owe his ex-wife $10,500. However, they determined that Mr. Murray had $2,595 in credits, but that he had also paid $14,552.38 in necessities to the child that he obviously provided proof of at the hearing. Uh-oh, now we've got a problem. The net result of the court order was that now Mr. Murray was owed $6,697.38 plus interest from his ex-wife. But wait, there's more. Obviously, Mr. Beard saw he had a problem here. So if you'll remember, the agreed settlement order was filed on both parties had signed on October the 15th. The $10,000 was paid. So Mr. Beard on November the 17th filed a motion for relief because the court order was down and we had an agreed order. So he asked for a motion, he filed a motion for relief and asked the court to determine which order was in fact the one that should be followed. And the trial court found that the agreed order was binding on the parties because they had signed it before the agreed order the court's order had gone down. Great. So now Mr. Murray has paid his ex-wife $10,000, but he's got a ruling from the court that he should be owed money from her. So now what happened? Well, I guess you could figure out that Mr. Murray filed a complaint against Mr. Beard for professional negligence, malpractice. His allegations were that Mr. Beard had advised him to settle the case before he had read the court's order and made sure of what the court ordered be done. And the allegations of Mr. Murray's complaint were that Mr. Beard's negligence fell below the standard of care of a trial lawyer. Pretty much, he didn't do what I, as a client, can expect him to do. And he requested $16,697.38 in damages, which was the $10,000 he paid his ex-wife plus the $6,000 that she owed him. So the trial court went through all their steps for everything that relates to a hearing, all the stuff they're supposed to do. And ultimately, a judgment was entered against Mr. Beard in the amount of $16,697.38 payable to his, I'm sure now, former client, Mr. Murray. Mr. Beard appealed the decision to the Court of Appeals, but at the time of the panel's hearing, which this case is based on, the Court of Appeals hearing was still pending. Now, on August the 4th, 2006, the Board of Professional Responsibility, not the court, not the trial court, not any court, but the Board of Professional Responsibility, filed a petition for discipline against Mr. Murray. Now, the reason it says supplemental petition against Mr. Murray is because he had another petition out against him at the same time. And when Mr. Murray filed his complaint, they assigned it to the same panel that was already looking at Mr. Beard. So they just made it a supplemental petition. So the hits keep coming. We find out in reading the case that a Mrs. Lopez had hired Mr. Beard to represent her in a case, and he had lost notes and not filed an order. He had done lots of things in her case, and she had filed a complaint against him. And then we also found out that there was a juvenile matter. We don't know the names of the parties because it was a juvenile matter, but there was a juvenile matter that Mr. Beard had handled horrendously. It was a terrible representation, and so that matter was before the board. So what the trial court did, or what the disciplinary board did, was combined these three complaints against Mr. Beard and had one hearing on all three complaints. So They went through all the stuff they did. They looked at all three complaints, and they determined that based on the allegations they had, Mr. Beard would receive a 2-year suspension for each complaint running concurrently. Now, Mr. Beard, he appealed the board's decision to the Supreme Court, which is why we have actual Supreme Court case from Westlaw as opposed to just a board decision, and we actually have a Supreme Court case. But the Supreme Court determined that because of the seriousness of all the complaints against Mr. Beard, not just in these 3 cases, but he had several complaints against him, because of all of that, the board was totally justified, and it affirmed the board's decision that Mr. Beard be placed on 2-year suspensions for each complaint, these 3, so 6 years running concurrently. Thank you.